Okay, I have said before I stopped the recording we'd continue on, but I've been thinking about it. I think the core points that I wanted to make have been made, and that we've had enough playing around with the agreement to get a sense of how to read it and how to think about it. I wanted you to do that because that first assignment, well, it's actually not a first assignment, is it? It's about the third assignment by the time you get there, but the next critical assignment requires you to make some changes to a term sheet or to advise on changing that term sheet. Now, how you do that is really completely up to you. There's got a couple of questions this morning that were asked that I just want to clarify on because I didn't think to put them in that little video I made. One is when I am counting words, which, let's face it, I'm probably only going to do if you are way, way, way over. But, you know, I'll say that. When I'm counting words, I will not count footnotes, I will not count references, and I will not count the text that you already had to deal with. So don't put up the agreement thing. I'm going to have to just slash and burn this term sheet just so I get my word limit, you know, like... You know, I'm not an asshole. Well, maybe I am, but not in relation to that stuff anyway. So think about that. The idea of that assessment task is to make it as authentic as it can possibly be. Now, in the real world, you would probably go in and just talk to your boss about it. You can't do that this time. You're just going to have to write a memo because that's how it works. I don't mind how you set that up. So it is usual to start with, because your first reader is going to be the boss, start with the memo, unless you've got a really good reason not to, and basically do the usual thing. Identify what the real issues are, what research you did, how does the law apply, what is it that you think are the key issues that need to be dealt with, and how are you going to deal with it. Research in this context, it is going to require you to look at the law and some cases potentially, but it's also about actually how do I make sense of this transaction in a useful way. So research might also include looking at transactions in the newspaper or otherwise that could be relevant, that you can learn from in some way. Again, a good look at the criteria, good mix of primary and secondary sources. A primary source would include ASX's website, documents that are actually issued by companies that are on the public record. ASIC regulatory guides can be really helpful to you. So a range of different, because even though I guess technically an ASIC regulatory guide is a secondary source, it's basically telling you how the regulator applies the law and what they think that the law means. Doesn't stop you from doing it differently and going and having a fight with them later on. But I think that's a really good way of getting a sense of what it is that you need to do. And then from a setting out perspective, I am more than happy for you to just take that document. You can scribble on it if your handwriting is legible, I don't care. You could use comments to the side, you could use footnotes, you could do anything like that to basically point out to Dennis where you think questions need to be asked or where changes might need to be made or what those changes are. So I've used the term a markup, but I don't care if it's old school markup by hand. Some of you might feel more comfortable creating some sort of table and identifying what the key issues are. It would be really handy to me if you cross-reference that, if it's an issue that's arising in the document, if you gave a clause number or something, so I can go up and down. But again, remember, you know, like Dennis, if you've seen how messy Dennis's office is, if you've watched The Castle, giving him thousands of pieces of paper, chances are he's going to get lost. And me scrolling up, scrolling down, scrolling up, scrolling down. You can miss things really easily, and I don't want to miss them. I'll try not to, but find the way to communicate what you think the issues are and the changes are in a reader-friendly way as much as you can, because as much as presentation is only sort of this much of your mark, it does go to the strength of your arguments in some way, the order that you choose and the structure that you use. So I said before I was going to continue on looking through the documents. That way I'm not. I am happy to answer questions about the documents and pull those things together. But what I do want to talk about is just, again, really high level, just to point out these things that we've been talking about. So again, these are, what I've tried to do is identify what the common provisions are in a range of these documents, and how it's structured will impact the importance and the depth that we go into. So we talked about background and recitals. Definitions really are key drivers to understanding these documents, and I would really start from the very beginning to get used to going and looking at the documents. And there is value when you're trying to understand a document, both in starting with the definitions and then seeing where they're used, but when you are reading the document, having the definitions by your side so you can have a look at them. Conditions precedent. Is everybody feeling fairly comfortable with how conditions precedent work? Thinking about when an agreement ceases if a condition precedent isn't met. So technically, if you have an agreement on foot and it terminates if a condition precedent isn't met, technically that kind of condition precedent is actually a condition subsequent. A condition precedent, used as a technical term, means a condition that must be fulfilled before an agreement is on foot. So technically, most CPs are actually condition subsequent. We have an existing agreement that gets terminated if it hasn't been fulfilled. Another thing that we need to think about, both from a share and asset point of view, is how do we know when conditions precedent have been fulfilled? What evidence do you need? And that will often go to your completion agenda. You have a kind of checklist of things that you do. We looked at that in the agreement as we went. You didn't get this far down in the agreement, but something that you will see in pretty much every agreement that relates to a change of control will include who pays the costs and who pays stamp duty if it's applicable. So usually each party pays their own costs, but there might be specific elements of the costs that are given to one party to pay for. So for example, we were speaking earlier about intellectual property investigations. It is quite usual for the vendor to pay for that report. And they pay for that because they are happy to, they would rather pay for that than have somebody crawl through their IP in relation to that. Also, they often get additional information out of it that is useful. Stamp duty can be really complex. Definitely changes from state to state, although they tend to go in waves. So up until relatively recently, there was stamp duty in most states on the transfer of non-listed company shares. But as soon as one gives it up, the other states tend to follow, because particularly, so technically, companies were registered or incorporated in different states, but that power has effectively been ceded. And so even though there is a technical registration in a state, Australian companies are now Australian companies. So the question of stamp duty went to where the register was located. So as soon as one state says we won't charge stamp duty on share transfers, then everybody's moving their register to that state, right? So stamp duty often goes to the underlying asset, so much more relevant in an asset acquisition, but there are what are called the land-rich provisions. So you cannot avoid stamp duty on the transfer of real property by just putting the asset in a company from the very beginning and then selling the shares. So again, this issue sort of came up when stamp duty was eradicated from share transfers. People who've got land in their companies are like, awesome, we can now transfer that land without without attracting stamp duty. And of course, the revenue officers said no. If the significant asset is land, then we're going to charge you duty anyway. But it can be quite complex, and sometimes the structures that arise out of transactions, the effort that goes into minimising the amount of stamp duty that's paid, I do wonder whether or not it just doesn't shape transactions in odd ways. So with a business sale and purchase agreement, we are regularly seeing these kinds of provisions. So transfers of IP, real property, both own and lease, plant and equipment, which also might relate to lease. So everywhere there's a contract, we might be looking at an assignment or a novation or a new contract. Undertaking a stock take, and clearly all of that feeds into ultimately the warranties. So provisions that specific to debtors and creditors, we've looked at this to an extent, but ultimately there's a commercial decision first and then the drafting follows. Who takes responsibility for debts that are incurred prior to completion, and the collection of debts that are owed prior to completion. And there are as many different ways of doing that as there are commercial people and lawyers available. Warranties and indemnities. So all liabilities in a share sale and purchase form part of the sale. So it is not at all unusual to have some kind of protection about unexpected liabilities. Sometimes that's addressed by restructuring prior to completion occurring. So excising out an asset, transferring a contract, receiving waivers or declarations from parties who might actually have rights, settling litigation. So often there will be a big clean-up even before you put the company on the market. I don't think there's anything in there that we haven't actually spoken about yet. I have mentioned W&I, warranty and indemnity insurance, a couple of times. It's becoming increasingly popular. Well, having said that, I haven't actually done a transaction for the last year because of the nature of the work that I've been doing. More and more into 2018, it was really on the rise. Any of you working in the space, are you seeing any change to that? You're not seeing it used? Okay. So again, I'm probably talking over $5 million before it's worthwhile. Premiums are not expensive. They're usually about somewhere between 1 to 1.5% of the amount insured. I've seen it up to 3% a few years ago, but the higher premium cost, I think, was probably represented the higher risks that were covered. So effectively, lawyers often sort of talk about insurance as being the solution to everything without necessarily being realistic about whether you can get the insurance, but more and more these kind of insurance policies are available. Often paid for by the purchaser, so the purchase price, the total cost of the purchase includes a percentage here, so they're the ones who are negotiating the term, they're the ones who are actually doing making the claim, so they need to be parties to this. So even though it's technically paid for by the purchaser, when you think about it, there's kind of a reduction of the purchase price, and so the vendor's getting a little bit less money than they otherwise might have got in exchange for coverage in the event that there is an issue with the warranties and indemnities. So again, as a lawyer, what we're doing with these kind of policies is making sure that the policy wording represents the agreement that we need to have between the insurer and the insured. So in particular, we're looking at exclusions. What things won't they cover? We've got to make sure our client understands that it won't actually necessarily cover all of the costs that are involved. So, for example, the costs of making the claim and litigating the claim, if that happens, are rarely covered by the insurance itself. Also, the coverage periods tend to be shorter than the time limits for the promises that are made. So when you think about it, when an indemnity or a warranty is given, and it's time limited, and Grace had a question earlier, which I'll come back to now, was the statute of limitations means that you can bring a claim for a breach of a contract at any time from up to 7 years after the breach has occurred. So then you kind of run out of your time limited. But coverage is only for 3 years. Now, the reason why wouldn't you bring a claim within the 3-year period? It's probably because it hasn't come out of the woodwork yet. So it's only things that have come out later. So Grace's earlier question was, tell me if I've misremembered, but when you're giving warranties, when do the warranties need to be true? I mentioned earlier that they usually need to be true at completion and at the time that the contract is signed. But it's not unusual to have some warranties that might need to continue to be true for a period of time. So, and I'm using warranty here in the sense of promise. So some of them will be necessarily time limited. So a restraint, for example, a promise that you will not compete with the business, or that you will enforce any rights you have under other constraints, might in fact be a promise that you are required to keep for a longer period of time. But when we're talking about factual warranties, how much money is in a bank, value of stock, knowledge and litigation that's on foot, those tend to be at particular times. So, for example, litigation is a really good one. At the time that you enter into a contract, one of the things that you will promise is that you've disclosed all pending litigation that you may be aware of. And it might be at litigation that's already on foot, but it might also be things where you have you have some reason to believe that there might be future litigation. And then you will need to give that warranty again effectively as at the completion date, which may actually mean more disclosures between signing date and completion date because something else has happened. Now, in a higher, so if you are buying a business that has used or mined asbestos in the past, sells products that might now be considered to be unhealthy, ranging from tobacco to energy drinks, so to guess, those kind of warranties will be more important. So again, it goes to risk as to whether or not further disclosures might be needed. Did that answer your question from earlier?
Yeah.
Okay.
I think you said before, in the property.
Yeah. So.
Or it doesn't.
Yeah.
It doesn't. So.
Clean-up obligations would quite often extend beyond settlement. So if particularly in a mining or I've seen a continued clean-up obligation where effectively a vendor has promised to pay for clean-up where a property was purchased that used to be a petrol station, so it had underground tanks. And so they preferred to have, and it was a large business, in fact, I think it was a petrol supplier. They preferred to take on that obligation themselves because they had in-house expertise to do it. But it's quite likely that that obligations in relation to that kind of cleanup might change. So they're outside regulation. And so that was a few years ago. It was relatively rare for promises that relate to numbers to continue on. Certainly promises about confidential information and restraints
What
will.
about disclosure?
So, if
it comes out later on.
if you become aware of, that's a promise that, so if the promise that was made is everything has been disclosed, and then subsequently you find that there was information they didn't have, or say, case names, they are really the bane of my life. I cannot remember them. The case involving the poor woman who died after long running dispute with British American Tobacco, and part of the reason for the dispute was that the law firm that was acting for British American Tobacco at the time, Clayton Utz, was advising in relation to document retention, which was really a document destruction policy. And so because certain types of documents were being regularly and robustly, shall we say, destroyed, information that was being requested as part of discovery wasn't available. So with those, we can end up with those kinds of issues in a sale and purchase transaction very easily. It's like, if you don't want to know about a risk, having document destruction policies or document retention policies that mean you're destroying information about the potential risks can mean that something doesn't come out of the woodwork for a very long time. If the promise is, we've disclosed everything that we knew about, it may well be that subsequently you found out that they could have or should have known about something and it wasn't disclosed, and so you've got a breach of that promise, even though you only find out about it later. So, and then the statute of limitations effectively addresses how long you have to make that claim. And sometimes the document itself might specifically address what the period of time is. You looked like you had a question.
Yeah.
No? Any other questions here? So we've talked quite a lot about exchange and completion as well, and conduct. I'm not really wanting to talk much about yes, I will talk about one thing that we didn't specifically cover. For the SPA, so the share purchase agreement, often the completion clauses will include provisions that ask for votes to be made on resolutions, quite specific votes in the completion ceremony. So that will include, for example, the filing of all of the resignations of all of the directors immediately after the current directors appointing new directors. And again, when you have a sale and purchase of shares, often making sure that you know who the directors are at a particular point in time can be quite important, because they're the ones that have the duties. It's also often a good time at completion to clean up constitutions, or so you might end up with a shareholders' resolution to approve the transaction itself. Payment of the purchase price. We've talked about how the payment might be structured differently. We haven't talked very much about different types of structures, but there are many different ways of working out how the purchase price is calculated, when it's paid, and in how many different ways that it's paid. When we get together tomorrow, we'll talk a little bit more particularly about using shares as consideration, because particularly with the closest thing the Australian law has to a merger transaction on market, so whether that is as an off-market or an off-market takeover bid or a scheme of arrangement, it is not uncommon for listed company transactions to involve, other than the payment of cash, the issue of shares as consideration for the purchase of shares, to effectively make what were two listed companies to create, one becomes the subsidiary of the other. So a couple of issues can come up there, particularly around valuation and also timing and escrow, in the sense that those kind of deals, people don't tend to want to do them unless the whole deal is going to go ahead. So what the conditions are to market bid going ahead. And the thing we haven't spoken about, and that I'm pretty sure I'm going to end up with today, is what happens after completion. So we have spoken a little bit about assistance that the vendor might be required to give following a deal finishing, whether it's shares or it's assets. It's particularly important when the purchase price is calculated on the basis of how much the business earns after completion has occurred, because in those circumstances, vendors want to have ongoing control of the way the business is operated, even though they are no longer the owners. When we have share transactions, clearly we need to make some changes to directors, to company secretary, to the auditor, could be to the location of the register, etc. ASIC has lots of different forms for lots of different things, and often the easiest way to work out what they are is to just go on the website and see what you have to lodge a form for. I've got to say, actually, that the last 5 or more years, the ASIC website has got really useful. You can kind of drill in, like, I'm selling my business, what do I need to do? And it gives you the forms, it gives you the background there, and I think it's become a lot easier than it used to be. There will be filings that you need to do. Stamp duty is not an ASIC filing. I have no idea why it's sitting in relation to that. But if you have to do stamp duty filings, you do those with the state revenue officers in each of the relevant states. Again, got to say, they have really lifted their game recently. It's so much easier now to do all of that sort of stuff online.
Apparently the information sharing a lot more too.
Yeah.
So, you might lodge a transaction in New South Wales, and then Western Australia will be calling up going, where's our documents?
Yeah, exactly. But also, just from the point of view of working with the officers too, often, again, this is in the very olden days when we were dealing with paper documents and stamps and seals. You really had to coordinate your stamp duty, because there are fines if you don't lodge in time, but you have to lodge original documents. So if they're spending too long in one state revenue office, you had to coordinate and made sure that the other one knew you were coming and that you weren't going to get a fine. And again, thank goodness for you all, that kind of work is really, it's disappeared. Everything can be lodged on, well, as far as I know, everything can be lodged online these days, and you get a nice little... The stamp is literally no longer a stamp. It is just a letter that you get confirming that it's there. I tend to attach them to the document, to the original documents, so that it's there for the client. But again, you can also search now to ensure that stamp duty has been paid. There was no way of doing that when you were literally affixing a stamp to the document. All these things I have learnt that are no longer relevant.
Well, it is relevant, because you often, I work a lot with trust deeds, and a lot of the older trust deeds do actually have the physical stamp.
Yeah.
And, to know what that
means. And the faded, well, a lot of old trust deeds, the older ones are, like, they're typed, like they're actually... It's something we don't actually see anymore, but it's like they become kind of embossed, because the type, the old... Yeah. Letters hitting, it's actually quite a different experience. So
and they'll have, like, I don't know, $2.50 or £2.50 or something on it. So.
And usually in pencil with the because the way that they used to do it is they'd write in pencil and you'd take it to the stamp duty office and you throw it on. But it was also, it's kind of a form of privacy then. There wasn't really any record keeping at the stamp duty office as to what had been done and what hadn't. So
the last bastion of the original signatures is really real public transfer.
Yeah.
Still have to execute them all, but every building the original document, 3 whole days, don't have to do that.
I am actually not convinced that the law requires you to do that.
I think so, like,
Banks
Yeah.
banks like original signatures in the right colour pen and things like that, but and a lot of places, insurance companies, they get all sort of caught up in the so-called wet signature, but I am absolutely unconvinced. But I don't trawl the legislation to regulations to see if there is a particular version. But it's a fight that's really worth having. Stamp duty, equipment leases, vehicle registration, land, all of those things may require stamp duty being paid, so it's worth having a look. Notifying changes, particularly the things that are on this slide are really for a business in particular. Notifying customers of changes in relation to bank details and ABN, and changing your invoices. Often acquiring a business, you will assume the same kind of software, etc. You may in fact need to buy new software licenses. Less and less of an issue now because a lot of those things are as a service anyway. It's being paid for every month. It just swaps over. But again, you need to make sure that the invoices have your ABN on them, not the old guy's ABN on them. And you need to notify appropriately. And that is pretty much, I have left out a chunk of slides in the middle because I think we talked about all of those things. I'm very happy to go back to them, but I'm also very happy to let you go if you guys want to do that, because we've got a really big day tomorrow. And so tomorrow we're going to be talking in particular about, getting tinnitus or something. We're going to be talking about takeovers. It really would be useful for you to make sure that you read the Redmond chapter on takeovers before we begin, because there's a lot more regulation and cases. And again, I'm going to speak to it in the high level way that I have been for everything so far. I want to talk about the practicalities, what happens and how it happens. But everything we've been doing today there is no law that says you have to buy and sell a business this way. We're talking about what the practice is, what the documents look like, and we're really talking about it's 80% contract law and a little bit around the edges with some tax laws that are relevant to the business type or industry, and if you're ASX listed, a little bit there, and corporations law in relation to the actual share transfers. When we're going on market with takeovers, it is entirely driven by the legislation, and the cases all deal with interpreting the legislation. We will get really bogged down if we're going case by case by case, so I want to keep it relatively high level and look at the cases where we really need to, but there will be real value in you reading that chapter so we can have a robust conversation. You too at home, can't remember if I'm recording or not. Okay. All right, thanks for your cooperation. It was a long day and we didn't take many breaks, so thank you.
Thank you, Charles.